Thank you, David. If you want to have your lunch spoiled, sit next to David for lunch sometime and just ask him where this is all going. And I had that privilege today.
You still.
I still ate my lunch. I've been at this for a while and acclimated. Ernest Hemingway made a statement. He said, people go broke slowly and then all at once. And we simply know you can't print prosperity. These issues are tremendous. The point of what we've assembled today is for you to get questions answered, for you to satisfy your inquiry of where are we in this story? Where do we go from here? How do we solve this problem? What are the risks to taking this effort on to try to solve the problem? And then for you to be able to lead your colleagues and to lead colleagues in other states. At this portion, I want to introduce a couple of others that are here on the dais and then open up to your questions. And throughout the event, we'll have some polling questions as well. I would direct you to, on the participants panel, we have Neil Schurer in the back. Neil's been very actively involved with Path to Reform and Article 5 efforts to move states toward the Article 5 effort. Neil is going to be fielding questions. And so as you have questions, if you want to chat those in, if you'll chat those in under the participant box and chat those to Neil, whether you're in the hall here or whether you're online, chat questions to Neil. We'll aggregate those in and be able to moderate those to the panelists. On the stand with me today as well, and with David Walker is Dr. Barry Paulson. Dr. Paulson is an emeritus professor of economics at the University of Colorado and a visiting professor at universities around the world. I was astounded in his bio. Universities in Guadalajara, Mexico, Cambridge, North Carolina, Japan, the Konan University in Kobe, Japan. I lived there. My oldest daughter was born in Kobe. And universities in Spain. Dr. Paulson's written a number of books on economics and economic development, economic history, and has been a leader in this Article 5 movement and the economic standpoint and the solutions that we need to move toward. Dr. Paulson is also an advisor to the Task Force on Tax and Fiscal Policy here with the American Legislative Exchange Council. Also with us today is Professor Robert Natelson, and I am delighted to have Professor Natelson with us. He is one of the foremost, if not the foremost scholar on Article 5 issues in the nation. He has written at least 8 major Article 5 studies, has been cited by the Supreme Court and other lower courts on numerous occasions for his scholarly work, and has been at the forefront of the work on Article 5 and the safeguards for states to move forward in this effort that is the power given to you to restore and maintain fiscal sanity in our nation. I will mention to you that I used Professor Natelson's book, The Original Constitution, in the American Federalism class that I was able to teach at Utah Valley University. It is excellent. I highly recommend it to you. He also has another book on the law of Article 5 and is the author of the ALEC Guide to the amendment process. At this point in our panel, I want to throw a few questions out as you all are working on questions. We want to look at, David Walker has just laid out for us something that is quite stark, and we know this intuitively. You can't look at a $28.5 trillion debt that is accelerating at rates that we can't keep slides and cartoons and documents up to date fast enough at the rate the debt is accelerating. And I guess some of the questions I would throw out to whomever would like to start initially and to focus on Congress. Congress certainly has a responsibility for fiscal sanity, you would think. Where is Congress in this picture? Where is it simply up to the states? Is it only up to the states? Does Congress not have a responsibility? Will Congress ever accept that responsibility? And if not, why not? And I think I want to throw that out to just some opening remarks to the panelists and invite you, as you've got some very noted economic scholars and political scholars and legal scholars, to look at the questions that you may have. But I want to throw that out just initially to whomever wants to take that. David,
I'll start out first. Congress is a big part of the problem, and Congress ultimately has to be part of the solution. With regard to statutory approaches to deal with this, they have not worked. That's why we need a constitutional amendment. There are a lot of people that in Congress that don't want to deal with the problem until you've got a crisis that forces you to deal with it. We don't want the kind of crisis that this would cause. and the tremendous economic disruption that this would cause in the country. And so as a result, I think the states need to stand up, and the states need to be leaders in trying to help make sure that we can enact a responsible fiscal sustainability amendment. At the same point in time, Congress is going to have to make the tough choices on what to do on spending, social insurance programs, taxes, budget reforms, those types of things. And in order to be able to do it, there's going to need to be some type of a statutory commission that has been bought in by the Congress and the president that actively engages the American people with the facts, the truth, the tough choices, solicits their input, makes recommendations that will be guaranteed a vote in Congress. That ultimately is going to have to happen as well. But you have to be able to be this force that makes sure that there is a mechanism that will force them to make tough choices before we have crises.
Barry, if I can kind of preface, the first book my father ever gave me was a book called Burning Money. And it was involved with the Grace Commission in 1984, and they talked about the $600 hammer.
Right.
And in the 1984 commission, they said, if we don't get this deficit spending under control by the year 2010, we'll have a $13 trillion debt.
Well, as you know, there a number of commissions have been appointed over the years to address these issues. We were talking about the commission that was formed back. Let's see, that was the BS Commission.
Paul Simpson, right?
You're not supposed to say that, but that's what it was. And unfortunately, these BS commissions have done BS. I'll leave it at that.
Yeah, part of the problem is the Bowles-Simpson Commission was not statutory. It was not guaranteed a vote, and it did not engage the American people actively until after they had come up with what they thought the right answer was. That's not the way to get things done. But again, while something like that is going to have to happen, it's got to be informed by what didn't and didn't work last time. We need the constitutional amendment.
Rob, if I can turn to you, structurally, are there structural legal impediments that impede Congress from keeping fiscal sanity? Why are we here?
We're here because in the 1930s, the Supreme Court stopped enforcing the restrictions that the Constitution imposes on Congress. So there was a famous case, 1936, that basically opened the light to Congress, the green light to spending in Congress. Whatever you deem to be Congress for the general welfare, it's constitutional to spend. And that created a situation where the pot, if you include debt, is potentially unlimited. So Congress became a huge auction house. There were, of course, some people who went to Congress and determined to try to end that situation. But without a constitutional restriction to back them up, they found themselves helpless. There are enormous incentives in Washington, D.C. to spend money. There are very few incentives to save money. Let me just give you one example. Let's suppose that a group of lobbyists comes to you, a member of Congress, and says, we would like to have a new Framis Museum. Don't have to see what a Framis is. We'd like to have a new Framis Museum in Akron, Ohio. And you say, I'm sorry, but there's nothing in the Constitution that authorizes Congress to spend money on museums in Akron, Ohio. And the response of the lobbyists is, well, you know, your colleagues say that there is, and so we'll ask one of your colleagues to sponsor the bill. And we'll also remember that you refused to help us out. And so unless you happen to be from a very safe district like a Ron Paul, it is very, very risky to say to lobbyists, no, we're not gonna spend anything. And that is because of lack of constitutional structure. And part of what the reasons we're talking about Article 5 right now is to reassert, to reimpose constitutional structure.
Thank you, Rob. If you'll get ready to cue the first polling question, I'll share with you. I was back in DC in, I think it was 2013. It was the fall of 2013. And this was the period of time when the Muslim Brotherhood had just won the election in Egypt, and they were now in power and in control in Egypt. And the US was still giving billions of dollars to Egypt in foreign aid. And I was kind of dumbfounded by this. And Michelle Bachmann, the member of Congress from Minnesota, Wisconsin, somewhere up in the frozen tundra area. Congresswoman Bachmann had introduced a resolution to defund any foreign aid to Egypt as long as the Muslim Brotherhood was in power. Their reason for being was death to America and death to Americans. That was their slogan that they won on. They're now in power and we're giving them billions of dollars in foreign aid. And so she was running a resolution in the House to end the foreign aid to Egypt as long as these sworn enemies of our nation were in power. She couldn't get the resolution to the floor of the House, controlled by her party. And I was dumbfounded by that. I'm in Washington and I just scratched in my head. Why in the world? This is like the biggest no-brainer in the history of America, that we would not give billions of dollars to people that literally won on a platform of swearing to kill us. And I had a good friend back there who was actually here this week that said, let me explain it to you. Here's how it works. We send billions of dollars to Egypt in foreign aid, and that comes back to lawyers and lobbyists and trade associations and accountants and their family members, to members of Congress on both sides of the aisle, and it's the easiest money they raise all year. And so that money will not go away. And you multiply that, not just foreign aid, but there was a study that I used in my class that I believe was a University of Kansas study that said the return on investment for lobbying Congress on major legislation, I just invite you to guess at this, the ROI, you give $1 million lobbying Congress, what do you expect to return on major legislation? Study showed 20,000% ROI. You can look this up. 20,000% ROI for lobbying Congress on major legislation. And so when you look at why is Congress not addressing this, as Rob mentioned, the structural impediments are such that to get reelected and move forward, there's no incentive to cut down their own gravy train that is basically the reelection fund. But any comment on? Okay, I've got a question here, and then we'll go to, do we have the polling question ready to go? I have a question for you here. Let's go to the polling first. The first polling question we have for you in the room and online. And again, if you change your name in, our first polling question is, do you believe that Congress will address the unsustainable deficit spending without an enforceable state drafted and ratified fiscal responsibility amendment? If you're online, you can log in. You should have the poll screen up. Does anyone not have the poll screen up on their device? If you don't, if they'll raise your hand, we can get some in the back to help. You should have a poll question up. Will Congress address the unsustainable deficit spending without an enforceable state drafted ratified fiscal responsibility amendment? So you should be able to open that up and click and submit. We'll keep that open for another 15 seconds. Anyone not had the opportunity to get to that? Is it not working? You got it? Okay, we have some of the polling showing up differently. May, if we have some that can help with the device, if you just raise your hand, we can get some to come help. Oh, good, okay. Okay, I think we're good. All right, do we have our results coming through? Are we closing the poll? All right. Poll closing in 10 seconds. All right, while that's happening and they're getting the results going, I've got a couple of questions for our panelists. First question. What will make Congress follow a ratified constitutional BBA amendment if they're not being fiscally responsible now?
You have to have an enforcement mechanism. One of the ideas for an enforcement mechanism is if it's violated, sitting members of Congress cannot stand for re-election. They lose their job.
Any others, Barry?
Actually, I agree with that, but I think a less stringent is simply, if we have a constitutional law that says that the federal government must bring expenditures back into equilibrium with revenue. It must balance the budget and limits the amount of debt that they can incur. And that's in the Constitution. There is a reputational effect if Congress fails to accomplish that. That reputational effect doesn't exist now because everything is in statute. We don't have any really effective fiscal rules at the federal level now. And that's why we don't have a real budget at the federal level. With a constitutional provision that says that, one, you have to have a budget, a real budget, and secondly, you have to balance it and you have to limit debt. When when legislators choose to violate that type of constitutional provision, believe me, there are reputational effects. Kevin Lundberg will tell you in Colorado, we have a balanced budget amendment, we have a spending limit, and it's in the Constitution. And by God, you can be sure Colorado legislators pay attention to that, right? Thank you.
Thank you, Barry. Rob, do you have any comments on that?
I'm going to address that in my principal presentation, so why don't we wait till then?
Perfect, we'll go there. Second question, will a balanced budget amendment, fiscal responsibility amendment, increase income taxes or taxes in general?
I would like to respond to that because my good friend David Walker asked me to emphasize this. I'm going to present to you a Swiss-style debt break, which is a balanced budget amendment. And it does require that the U.S. must bring expenditures into line with revenue, and it imposes an expenditure limit, but it says nothing about revenue. Congress can raise taxes, lower taxes. It says nothing about revenue, but it does say you've got to constrain the growth of spending. And David asked me to emphasize that, so I'm sure he agrees with it.
I think you have to understand that there's a new four-letter word in fiscal policy at all levels. The four-letter word is math. Our hole is so deep, our challenge is so great that there is no way you can grow your way out of this hole. There's no way. Do we want to promote economic growth? Absolutely. Through reasonable tax levels, less regulatory burdens, of prudent investments, et cetera. But you cannot solve the problem by growth. The biggest problem is spending, reforming social insurance programs to make them solvent, sustainable, secure, and affordable, and other spending, reprioritizing and constraining other spending. Revenues are going to have to go up. Some of it will go up because of additional growth, but not all of it. And then the question is, what type of tax reforms do you need in order to accomplish the objective while recognizing the problem is primarily a spending problem?
Could I add to that, David? It's not only can you not grow out of debt, the current debt is causing economic stagnation, retardation in economic growth. Now, this is not a problem just for our grandchildren. This is a problem for our generation, because what we are looking at after this euphoria of throwing money out the last year, we are going to be back in the 1970s with slower growth, higher inflation, higher interest rates. We are going to have stagflation. And that is what the CBO projects, and that's what we forecast.
You know, I guess the way I remember as chairman of a chamber of commerce in a community here locally, we had Howard Stevenson, who was a member of the Utah Senate and chair of the Utah Taxpayers Association, came, and he was telling the Chamber of Commerce members, he said, you have to keep your eyes open that they're going to hide the tax. You have to pay for government, and if you don't have a direct tax, they're going to hide the tax anyway. And so I guess what we have now, if you don't have a direct head-on attack to the fiscal issues, we've got the Federal Reserve that's just simply monetizing and printing and devaluing the currency. And that's just simply a regressive tax on every dollar everyone's earned and everyone's ever saved. Is that a fair statement? And would you care to comment on that?
Oh, absolutely. And Ken, I have to point out that Utah is one of the few states where you have been able to constrain the growth of debt. The key here is we've got to turn that debt to GDP curve downward. At the state level, one of the few states to do that's Utah. And it's because you guys 10 years ago directly addressed what is the biggest source of debt in the states now, unfunded liabilities and pension and OPEB. You guys addressed that, and Utah has turned the debt to state GDP curve downward. One of the few states that's done that. I've got a 3-minute limit.
We appreciate the endorsement.
How did that happen?
Are we ready to reveal poll results? That's still coming. Okay, we'll bring the results back later. We're going to move on to the next segment that we have. I'm really delighted. I love to hear Rob Natelson speak. It just, he's been a friend for a number of years. I can still remember, honestly, I'm running for office. I wrote a little manual to myself on what I thought. I swear an oath as a state legislator, I would swear an oath to uphold the Constitution. I really wondered what that meant. And I did some research and kind of wrote down what I thought that meant and what the powers were. And I got a hold of Rob, and I still remember I'm a nobody, a brand newly elected legislator. And I can still remember where I was. I got a voicemail from Rob. He said, Ken, this is really good. I think we should get this published. And could I please write an introduction to that? And I was just thrilled that Rob Natelson had read something that I had written, and it's still a very memorable day to me. But with that fan gush that I put out to you, we have the opportunity to hear from Professor Rob Natelson on how our founders designed the Article 5 system for Convention of States to safely propose constitutional solutions to national issues. Rob, time is yours.
It is a privilege. I realize it's a cliche, but it happens to be accurate. It is a privilege to be able to share the platform with these distinguished gentlemen. I want to particularly congratulate Ken Ivory on becoming a grandfather. I was wondering why you looked so much older than the last time I saw you. Not really. We have a clicker here. Right there. That's it. Okay. I hope it works. The amendment process, as outlined by Article 5, is one of a number of parts of the U.S. Constitution where responsibilities are given directly by the Constitution to state legislatures. Another example that became familiar recently was the state legislative power to determine how presidential electors are chosen. The amendment power, like the power to choose presidential electors, comes directly from the Constitution. When you as state legislators exercise it, you do not operate under your own state constitutions. You operate under the U.S. Constitution. Now, we've heard some of the problems. One that we did hear about was the potential for fiscal ruin. I want to add another one to this list, wasteful and destructive spending. And let me tell you why I'm adding it. I'm a former academic. I'm a refugee from academia. And I can tell you that a great deal of the nonsense that comes out of academia is funded by the federal government. And if the federal government had to do things that were real, like national defense and pay for Social Security, then it would have less money to sow social mischief by its grant programs. So I see the fiscal responsibility cause as not just one for fiscal responsibility, but it's also for preventing social damage. We have tried all kinds of solutions in dealing with the debt problem. You all know about them. The final constitutional alternative is the amendment process. I think we can stipulate that after 60 years of trying other solutions that they have not worked. The amendment process is our most powerful constitutional tool, and I want to make a point here. Amendments work. They really work. You may have heard people tell you, oh, an amendment isn't going to make any difference anyway because they don't follow the Constitution anyway. That line violates every lesson of history. Women would not be voting in many states without a constitutional amendment. It was a constitutional amendment that abolished slavery in those states that the Emancipation Proclamation didn't reach. It was constitutional amendments that gave us the Bill of Rights. It was a constitutional amendment that imposed term limits on the president that have been honored ever since. So historically, you simply cannot say that constitutional amendments don't work. They do. Why is that? I don't have the complete answer, but I can tell you that one reason is that a constitutional amendment is a powerful expression of political desires by the American people. If you get a constitutional amendment proposed and then adopted by 3/4 of the states, boy, does that send a message home. And let me just give you one example. In 1793, only 4 years after the US government got started, the US Supreme Court, in a burst of judicial activism, expanded its own jurisdiction under the Constitution. Now, did the founding generation stand by and say, well, let's elect good people so we can put better people on the court? No, the founding generation responded by immediately passing a constitutional amendment, reversing the Supreme Court opinion. That was the 11th Amendment, and it has full force today, over 200 years later. Constitutional amendments work. If someone tells you that constitutional amendments make no difference, all that person is doing is revealing his or her historical ignorance. Next, a common story is we don't know anything about the constitutional amendment process, that a convention under the Constitution has never been held, that the courts don't take Article 5 cases, that we just have no clue as to how the state operated Article 5 procedure works. You know, I used to believe something like that. And then when I was at the University of Montana as a law professor, I undertook a study of the amendment process. And what I learned was I was really wrong. And a lot of other people are wrong, because there is an enormous amount of information about Article 5, including nearly 50 reported Supreme Court decisions. And what they tell you is that this law is federal law. It doesn't depend upon state constitutions or statutes. It is federal law, and it is a unit. The same principles that apply in the ratification process apply in the proposal process and at every step along the way. And the result of that, ladies and gentlemen, is that I can tell you how the convention process and how the Article 5 process works to a near 100% certainty. We've already done much of it, most of it, nearly all of it. In fact, in a sense, we've done all of it. There is very little uncertainty in what I'm going to tell you. There is uncertainty in one area, the area of aggregation, which I'll address later, but that doesn't concern us at this point. Okay, let's start at the end. We've got a problem. We want to deal with it. So we need a constitutional amendment. So how do we get it? Well, Article 5 of the US Constitution tells us how to do it. Article 5 does not permit any convention or any other body to replace the US Constitution. There is no provision in the US Constitution for another constitutional convention. Let me say that again. There is no provision in the US Constitution for another constitutional convention. So if somebody tells you that an Article 5 convention is going to be a constitutional convention, it's going to rewrite the Constitution, that person is blowing smoke. In Colorado, we would know what he's smoking. Okay. The Article 5 is limited to amendments to this Constitution. If someone tells you that, well, a convention or Congress or whatever can alter the amendment process by itself, I've heard that, you know, we need 38 states to ratify a constitutional amendment. Oh, they'll just change the ratification process. That person is also blowing smoke, because the question of whether any operator within the amendment process can change the mode of ratification or change other parts of the process has been before the courts again and again and again and again. And the answer is always no, you can't do that. there is a uniform stretch of precedent extending over the past century, which says that no actor, no convention, no legislature, no Congress in the amendment process can change the ratification mechanism or any other part of the amendment process. Okay, we need three quarters of the states to ratify. It can be done by either legislature or by conventions. The choice of who of ratification method is made by Congress. This is called proposing the mode of ratification. And for the most part in our history, Congress has sent constitutional amendments, proposed constitutional amendments to the states for ratification or rejection. However, when the 21st Amendment was before the people, Congress decided to send this amendment to state conventions. And that meant that individuals in the states could vote for convention delegates who were pledged either to vote for or against the 21st Amendment, that is to say, the repeal of prohibition. And so this actually gave the people of the United States, acting through their individual states, a way of voting on an amendment. And that's one reason why Dave Biddulph and other people recommend that a balanced budget amendment be ultimately sent to ratification conventions rather than to the legislatures. Whatever method is used, note that there's some commonalities between legislatures and conventions. They're both popularly elected. Like every other body operating under the amendment process, they operate under federal law, under the US Constitution. And they follow certain standard rules that have become the norms in the Anglo-American legal system. You may have heard this. If we had a convention for proposing amendments, what would be the rule of decision? Would it require 2/3 of the delegates? Would it require 3/4 of delegates? People who ask questions like that have never heard of something called the parliamentary common law. The parliamentary common law tells us how decisions are made in parliamentary bodies. And for those of you who are legislators in states that use Mason's manual, you will find many references to the parliamentary common law. And one of those is that in absence of a rule to the contrary, decisions are made by a majority of those present and voting, a quorum being present. However, it is also true under the parliamentary common law that a convention, a legislature, or any similar body can adopt its own rules. So Congress chooses a mode of ratification. We're backing up in time here. When can Congress choose a mode of ratification? Well, when it's got a proposed amendment. Congress simply can't decide, well, one day we'll choose a mode of ratification for what? Well, for nothing. There has to be a proposed amendment for Congress to choose such a mode. And there are two ways of proposing amendments. One that you're probably familiar with is Congress or a convention for proposing amendments. If the amendment is proposed by Congress, it takes 2/3 of each house. However, 2/3 of a quorum, not 2/3 of all present, because the default rule continues to apply. If, on the other hand, the method of proposing is by convention, then the convention is triggered by a congressional call, by the congressional call. Now, let me say something about the congressional call, because this is another topic that is the subject of a lot of misinformation. The misinformation I hear on this issue is, when Congress determines the call, they can control the convention. The same people who say the convention is uncontrollable also tell us that Congress can control it. I don't have time to get into their arguments. Let's just say the arguments don't have any legal reality. When Congress calls a convention, it acts as an agent of the states. And terms in Article 5, the courts tell us terms in Article 5 have the meanings they had at the time of the founding. And what a call means is you're invited to a convention at such and such a time, at such and such a place to discuss this subject, period. That's it. Congress can go no further. You know, we have a convention, a kind of convention that meets nationally about every 4 years, right? It's called the Electoral College. The Electoral College is in fact a kind of convention. It's a single purpose convention limited for the purpose of electing the president and the vice president of the United States, nothing else. So if someone suggests to you the convention might run away, you might ask if we should cancel the next presidential election because the Electoral College might run away. Okay, so when does Congress call? When does Congress call? Congress calls when it receives resolutions from 2/3 of the states, now 34, demanding that it do so. Sometimes you'll hear the word petition used to describe an application. People will say, well, Congress has to call a convention when it gets petitioned by 2/3 of the legislatures. Folks, it's not a petition. An amendment passed for a convention is not a petition. It is a conditional demand. It is a demand that Congress call a convention. And if there are 34 applications on a particular subject, then Congress has no choice. Everybody who's looked at it agrees on that point. One difference, a huge difference between the convention for proposing amendments and the ratifying conventions, which we've already seen, is the ratifying conventions are meetings of representatives of the people directly. But a convention for proposing amendments is a convention of the states. That is to say, it is a gathering of sovereignties together. It's actually modeled on international law. You know, you've probably heard of the Congress of Vienna. It's the same sort of thing in which sovereignties get together to negotiate solutions to common problems. And in such a gathering, each sovereignty is equal. Another good example is NATO. NATO is run by something called the North Atlantic Council. The sovereignties are equal in NATO. The smallest government gets the same vote as anybody else. And that is the nature of an amendments convention. One of the things I've heard an awful lot is the only convention we've ever had was the Constitutional Convention of 1787, and so we don't have any precedents. And I am embarrassed to admit that I sort of believe that at one time as well. In fact, we've had about 40 different conventions of states and parliament and colonies. The reasons why the founders chose the Convention of States mechanism for proposing amendments is it was really familiar. There had been about 20 conventions of colonies during the colonial era. And then after independence and the time the Constitutional Convention met, there were 10 different conventions of states. Roger Sherman of Connecticut, one of the delegates to the Constitutional Convention, this was his 6th convention that he'd been to. They knew this system very, very well. And we have continued to meet in conventions since that time. Not as often, but we have nevertheless continued to meet in convention. And the most recent was the Phoenix Convention of 2017, of which the great Ken Ivory served as vice president. All conventions of states have been limited. All conventions of states have been limited. In the case of a convention for proposing amendments, they are limited to proposing only amendments, and they're limited to the scope of the call. And they are also subject to state legislative instruction. Now, what are the chances of a convention under those circumstances running away? Let's suppose we've got a convention for the purposes of proposing a balanced budget amendment, and some clown stands up and says, "No, I think we should propose campaign finance reform," right? Well, first off, and we saw this at the simulated convention, immediately there's going to be a call to order. You're out of order, that's outside the agenda. And secondly, since the people back home are going to be watching, right, on their computers, the whole thing is going to be streamed. This guy's going to get a text message, which is going to say something like, sit down and shut up or come home. So the chances of a runaway under current conditions, and again, a runaway's never happened, including at the Constitutional Convention, that's a myth. The runaway has never happened at any of these conventions, but the chances of it happening now is somewhere between 0 and -1, because anyone who gets out of line can instantly be reined in by a call from home. So where did the story come that conventions are unlimited? Well, those people who are very, very conservative and belong to certain very conservative groups who spread the story that conventions are unlimited might be embarrassed to know that the myth actually was first disseminated widely in the American public by very liberal interests. It was in the 1960s and 1970s. Here's what happened. The Warren Court was out of control. The Supreme Court at that time was out of control. It adopted a number of decisions, including Roe versus Wade, the abortion decisions, that most states wanted to overturn. And so a movement developed for the calling of a convention for proposing amendments. In addition, the debt began to veer out of control, at least by those standards. And so a lot of people wanted a balanced budget amendment. Well, these were all popular amendments. So what is the liberal establishment to do? They can't attack those amendments head on. So they said, well, you don't want to call a convention because I'll run away, rewrite the Constitution. And believe me, this is something that Theodore Sorensen actually said, they might move the capital to Topeka. Strikes me as a reason for holding a convention, but at any rate, that's where it came from. It was propaganda introduced by liberal establishment figures in the 60s and 70s, and it had no historical basis to it. An Article 5 convention is called by Congress, but then it is formed by the state legislatures. Those of you who are state legislators, you are the guys who choose who the commissioners are or who's going to designate the commissioners. You're going to be the ones that determine how a state is going to cast its vote. You're the ones going to be giving the instruction to the commissioners. And if somebody gets out of line, you're the one sending that text message which says, come home. In sum, this procedure is well known, well understood to anyone who has seriously studied the history and the law behind it. 34 legislators can begin it at any time, and I urge you, please do so. Thank you. Questions at this point?
Well, I think so. We'll do that. And then we're going to come back and get to the other part of your presentation.
So questions.
Yeah. Let's yeah, we're gonna take a few questions. If we can get the poll question. Oh, no, I'm sorry. That's after his next presentation. We'll get to questions at this point. So I've got a question here. Does the current Congress have less respect for the Constitution than in the past?
Well, it depends upon what you mean by the past. I don't know if the current Congress has less respect for the Constitution than the Congress 4 years ago. Does it have less respect than the Congress did, let's say, right after the Constitution was adopted? Absolutely. When the Constitution, when the Constitution became effective and Congress first came together, one of the questions that they had to debate was the president may appoint officers, may the president also remove officers? Does the president need the approval of the Senate to remove officers? And if you study the constitutional debate on that question, or if you study the constitutional debate on the First National Bank, your chest will swell with pride. These are people who took their constitutional responsibilities very seriously. And I'm inclined to believe, from my historical hat, I'm a law professor, but I'm also a historian, that there was much more resort to the Constitution in times before the last 4 decades. I remember a few years ago when Republicans took control of the House of Representatives, it was right after the 2010 election, they decided to open up the session with everybody reading the Constitution. You know, a representative would stand up, read part of the Constitution, and another representative would stand up and read another part of the Constitution. And it got to be Nancy Pelosi's turn, and she starts reading a part of the Constitution. And as she's reading, she obviously skips over an entire page and continues to read and doesn't notice that anything's wrong. You may recall John Conyers, who served on the Judiciary Committee of the House of Representatives for 50 years. When he was asked the question of whether Obamacare was constitutional, and if so, under what clause, said, well, you know, a number of clauses. I think it's constitutional under the good and welfare clause. Well, there ain't no good and welfare clause. And a guy who served on the Judiciary Committee, the primary committee for dealing with the Constitution for 50 years, should know that. There is a very, very profound ignorance. And I think, to quote a word I learned from the great Senator Tom McGilvray, insouciance, carelessness about the Constitution among current members of Congress. So I'll stop the answer there.
Thank you. So again, if you have questions, if you would text those or in the chat room and chat, and you can pull down and see Neil Schur. And if you have questions here, we can perhaps pass a mic, but if you have questions online, you can chat those, and those will go to Neil and we can bring those forward. Rob, I have a question that just as you were speaking that came to me. You said Congress will necessarily follow their ministerial duties in issuing the call and in any other of the procedures that they may have. What happens if they don't?
Okay. Ken, being a lawyer, used one of our magic words, ministerial duty. And I will explain that to you. There are in law 2 different kinds of duties. There's what we call a discretionary duty, which an official may or may not exercise. And there are ministerial duties which an official must exercise. So if you go to the local official for a marriage license and you fill out all the paperwork and you qualify, then the clerk has to issue it. That's a ministerial duty. The founding era documents and the language of the Constitution tell us that the obligation to call a convention, if there are 34 amendments on them, relate on particular topics, that is a ministerial duty. Congress must call. So what do you do if Congress doesn't? Well, the immediate and most obvious answer is to sue Congress. And if that sounds silly, in fact, that happened a number of years. There's a number of years ago. There's a very famous case called Powell versus McCormick, in which Congress did something that was unconstitutional. Congress got sued, and the Supreme Court said, Congress, you acted unconstitutionally, and Congress responded. If Congress still does not respond, frankly, you have a revolutionary situation. And Mike Ferris, for example, who helped found the Convention of States movement, says in that case, if Congress refuses to call a convention of the states, then it's time for the states themselves to meet on their own.
Got a question here. Let's see if Congress is ignorant of the Constitution or will behave, what makes us think they can or will behave by its mandates?
Well, again, I addressed this at the beginning. That's part of the question that you get a lot from certain lobbyists who say, you know, they're not following the Constitution now. What makes you think they'll follow an amendment? So let me repeat this. I'll have to repeat it again and again to to some people anyway. And that is that the historical experience demonstrates that constitutional amendments work. That there are, as Barry Polson just said, very significant costs if you can demonstrate that a member of Congress is flagrantly violating the Constitution. I mean, when was the last time you saw the Congress passing legislation abolishing free speech in the United States. I mean, it doesn't happen. It doesn't happen because everybody understands that there's an amendment to the Constitution saying they can't do that. Sometimes they nibble around the edges, right? It's just like in your states, you almost all have balanced budget requirements, and sometimes you nibble around the edges of that. But by and large, those provisions do more good than they do harm. They do a lot more good. You know why most states have balanced budget rules? Because in the 1840s, several states went bankrupt. They repudiated their debt. And so during the 19th century, the voters started to introduce balanced budget amendments into state constitutions. And we've not had a state bankruptcy since. The fact is that a constitutional amendment is a powerful expression of political will. It is a direction from the people to those that represent them. You will do this. And I'm not a psychologist, but I can tell you as a matter of practical experience, whatever the reason, constitutional amendments work. They do. When was the last time, for example, some president tried to run for a third term? President hasn't, because everyone knows it's 2 terms, max, and out. And that is because we adopted the 22nd Amendment in 1952. Is there anyone in this room who thinks we would be better off without the 22nd Amendment? Or more to the point, is there anyone in this room who thinks that this 22nd Amendment has made no difference?
Thank you, Rob. Let me outline just a few of the next items in the agenda here. So we're going to hear from Rob again
I'm finished,
on this. We're not done yet.
but I'm finished answering questions.
We're done on that. I think we're done
Good.
with questions on this subject. We're going to hear from Rob again on the runaway convention delegate selection recall laws. There've been a number of laws to put some guardrails around the Article 5 process and for states to have control and have more security in how they may call delegates and how the delegates may attend a convention. So we're going to hear from Rob again on the no runaway convention delegate selection recall types of laws. We'll have another polling question. We'll come back to the results of the prior poll. We'll take a break at that point, and then we'll move on to the next part of the program as we move forward on ratification related issues. And then we get to the issues of ratification. We're sitting at the point of 33 states aggregated to the potential of getting states to an actual convention. And that's going to take everyone to get over that next hurdle. So with that as an outline, we'll hear from Rob again. We'll have another polling question. We'll announce the results of the prior poll, and then we'll take a short break. Rob, you're up again.
On aggregation?
No, on the runaway convention delegate recall laws.
My understanding is that there are multiple copies available of the book, the Law of Article 5. Is that right? Okay. What many states have done, 14 states, is that they've adopted laws that provide penalties to any convention commissioner who exceeds his or her power. I believe Indiana might have been the first state to adopt that. That is an additional way. It's kind of a belt and suspenders. We've already got the suspenders. This adds the belt to make sure that commissioners stay within the scope of their power. One of my written products on Article 5 conventions is a legal treatise called The Law of Article 5. It's a short read, and I guess there are about 40 copies of it available. At the end of the book, The Law of Article 5, you will see a sample runaway act. It's called the Uniform Interstate Conventions Act. And what it does is it balances the legal issues in such a way as to maximize the enforceability of such a law. There's some aspects of some laws that may not be enforceable. The bottom line here is that if after everything I've said, you want that additional suspender that 75th suspender on top of the belt and the 74 you've already got. Then you could adopt a delegate, a no runaway law, which punishes delegates who attempt to exceed their authority.
Yeah, I know that there were a number of states. I think, I don't know if you know how many states we're up to now that have done
14.
14.
14.
And so effectively that would limit the amount that would be necessary to defeat any type of a
Yeah.
convention going astray. You would need 13 essentially to block any type of untoward activity at a convention, would you not? And so having 14, does that not put you over that limit
Well,
anyway?
you mean, are you talking about ratification?
Right, well,
You.
oh, I'm sorry, yeah, I'm going a different direction,
The
correct.
convention operates by a majority vote unless the convention
No,
decides
that's
otherwise. So you would need 26. But again, you've already got the ruling out of order provision, and you've already got the come home orders and so forth.
Yeah.
However, if by some way, and I don't know how this would happen, I think it's roughly equivalent to the sun coming up in the west, unless you happen to be on Neptune where it does come up in the west. If somehow an unauthorized amendment came out of the convention, and if Congress nevertheless appointed a mode of ratification for it, which it could deny if the amendment were unauthorized, then 13 states could block the amendment. If the ratification is by state legislature, that just means 13 houses out of the 99 houses we've got could block the amendment. The real risk, let me tell you frankly, the real risk of regarding the proposal process, the convention process, the real risk is not that the convention is going to do too much. That risk is like zero. The real risk is it's not going to do enough, that it's not going to respond to the situation as David Walker has outlined it. Now, that doesn't mean we shouldn't try, but it means that the talking about the risk of it doing too much is completely the wrong discussion. The discussion is, how can we get the convention to propose an amendment that has teeth? And secondly, how can we get 38 states to ratify it? I think it's doable, but it's going to be tough.
And so, I mean, I guess the point is there are so many controls that you have as a legislative body in how you choose your delegates, how you control your delegates, how you limit your delegates to a convention. In the materials that are part of the conference materials, you have a number of examples of these no runaway ratification and delegate selection and recall types of laws. And again, if you have any questions going forward, you have the panelists and others to draw upon with questions that you may have as you're working in your legislative bodies. So we've got the results showing from our first poll. Should your state pass an Article 5 no runaway convention delegate recall law? And it looks as if our results seem somewhat overwhelming. I'm colorblind, but that looks pretty clear to me. So you see the results there. We're going to move to the next polling question that we have. Based on Professor Nadelson's presentation, the materials you have, do you believe your state should pass an Article 5 no runaway convention delegate selection or recall law? These are the states that have already passed them, I believe, correct? Okay, and we'll have a polling question. And as the polling question is going, if you'd like to take a break, we've got some refreshments out in the foyer and the facilities there. But if you can bring the polling question up. Again, if you've not on your name, under the participant section of your name, if you would please add the two abbreviated initials of your state. So if you'd put UT in your last name, AZ your last name, NH as it may be, if you'll go under the participant section, under your name, change your name and put the initials of your state, then your polling can come into to your state. We'll take just a short break as we have this poll go out. Please respond on the poll. And as we come back, we'll move to the next section of the program on ratification related issues. On what, on this? Oh. How you doing?
Hi.
Oh, yeah, bid off is up, but then I think you'll be back for other questions. So, and if we need to pull out on you.
Didn't he cover both his sections?
Uh-huh.
Because on the timekeeper assumed that he did.
Yeah, he's done on both his sections. Yeah, that's right.
imposing or granting rights out.
Oh, good.
That makes
Not
sense.